Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
It's great to be here.
Yeah, I'm really glad you're joining me today because I want you, the listener, to just imagine something for a second. Imagine walking into a courtroom.
Okay.
You have this massive stack of evidence, right? Like emails, witness statements, performance reviews.
Whole 9 yards.
Exactly. And all of it proves that your workplace is just an absolute nightmare. Your boss is undeniably cruel. The environment is super toxic. And you have suffered like measurable harm.
Yeah, you got the receipts.
You have the receipts. But then the judge looks at all your evidence, nods, and says, I believe every single word you're saying. I assume it is all entirely true.
Mm-hmm.
And I am throwing your case out.
Oh, wow. Yeah, that is a gut punch.
It sounds completely backwards, doesn't it? Like, we are all conditioned to believe that if we can prove we were wronged, the justice system will step in and provide a remedy.
Right, that's the expectation.
But the legal system does not operate on common sense. It operates on structure.
It really does.
So today we are analyzing a really fascinating excerpt from a legal court document. The case is Soysal v. County of Santa Cruz.
A very telling case.
Very telling. And before we start dissecting, all the procedural maneuvers and that dense legal language in the margins, let me give you the absolute bottom line ruling right up front.
Lay it on us.
In this case, the court granted the defendant's motion to dismiss Dr. Soysal's Title VII claims because she failed to allege that the conduct against her was based on a protected category.
Boom, just like that.
Just like that. And to help us translate the really rigid, often unforgiving mechanics of this decision, I've got our expert legal analyst here.
Thanks. Yeah, it's a tough pill to swallow for a lot of people.
It is, because when you read an excerpt like this, it becomes very clear that a lawsuit isn't always won or lost on the messy, emotional facts of what actually happened to you.
Right. Very often, it is won or lost on the highly technical framing of the law itself.
Yeah, exactly.
And, that tension, that gap between factual reality and legal framing is exactly what makes this document so revealing.
Oh, totally.
Because people tend to view the court as like a referee for general fairness, right?
Mm-hmm,
like if a foul is committed, the referee blows the whistle. But civil litigation, especially in employment law, it operates a lot more like a specialized machine.
A machine, yeah. I like that analogy.
Yeah, and if you don't feed it the exact right inputs, it doesn't matter how valid your grievance is.
Right.
The machine will simply refuse to turn on.
Right. It just sits there. So I really want to look at how that machine actually filters out cases, because the logic can feel, honestly, totally counterintuitive.
Oh, absolutely.
We know the court threw out the Title VII claims here, but how they justified doing it is what really caught my eye.
The footnotes, right?
Yes, the footnotes. Right in the first footnote of this text, the judge writes, and I'm quoting here, "The court assumes the truth of the allegations in the amended complaint for the purposes of Defendant's Rule 12b-6.
Rule 12b-6.
Right.
The classic gatekeeper.
Right. Okay, let's unpack this. It's like a bouncer at a club.
A very strict bouncer.
Very strict. You walk up and say you're on the VIP list, and the bouncer says, I completely believe you are on the list. I am assuming that is true. But you're wearing sneakers, and we have a strict dress code, so you still can't come in.
That is exactly it. And what's fascinating here is the functional utility of that assumption.
Okay, tell me more about that.
Well, a Rule 12b-6 motion, which, for the listener, is the federal rule for a motion to dismiss for failure to state a claim.
Right.
It's a very specific procedural tool. At this early stage of a lawsuit, the court is not holding a trial.
They're not looking at evidence yet.
No, not at all. They aren't calling witnesses to the stand to determine who was lying and who was telling the truth.
Oh, interesting.
Instead, the legal system intentionally gives the plaintiff the ultimate benefit of the doubt regarding the facts.
So they just say, sure, we believe you.
Exactly. The judge freezes the facts as you present them and asks a purely structural question.
Which is?
If everything you say is true, does the law actually provide a remedy for it?
Okay, I have to push back on that a little bit.
Sure, go for it.
Or at least I'll play devil's advocate for the listener who, might be dealing with a workplace dispute right now.
Fair enough.
If the court's ultimate goal is to find the truth and deliver justice, why on earth are they skipping the fact-finding part?
It does feel backwards.
It really does. It feels like the system is just looking for a technicality to let the defendant off the hook, before the plaintiff even gets to show their evidence to a jury.
I completely understand why it feels that way. But let's look at the mechanics of why the federal rules are actually designed this way.
Okay.
Litigation is incredibly invasive, and it is exponentially expensive.
Yeah, lawyers aren't cheap.
Not at all. If a case survives a motion to dismiss, it moves into what's called discovery.
Right, the document dump phase.
Exactly. That means subpoenas, depositions, turning over years of private emails.
Oh, man.
And you're racking up tens of thousands, sometimes hundreds of thousands of dollars in legal fees.
Just to get the emails.
Right. So the Rule 12b-6 motion acts as a vital gatekeeper.
The bouncer.
The bouncer. It prevents a plaintiff from forcing a defendant through the agonizing expense of discovery if the underlying legal theory is fundamentally broken.
Oh, I see.
Yeah, it is a test of legal sufficiency, not factual accuracy.
So you're basically saying it's a matter of judicial economy.
Precisely.
Like, if the law doesn't cover what happened anyway, there's just no point in spending 2 years and $500,000 proving that it happened.
That is the core rationale. The court is basically saying, let's assume you have a 4K video recording of your boss doing every terrible thing you claim.
Right. Undeniable proof.
Undeniable. But if those terrible things don't actually violate a specific statute, I have no power to help you.
Wow.
It filters out cases where the outcome is already legally predetermined by the boundaries of the law itself.
Man. Okay. Which brings us to the actual boundaries of the law in this specific case.
Right. The Soysal case.
Yeah. If the court assumed everything Dr. Soysal said was completely true, what was her fatal flaw? Like, what were the sneakers she was wearing that kept her out of the club?
It's all in the second footnote.
Yes. In the document, footnote 2 addresses counts 3, 4, and 5 of her amended complaint. And the text notes that these were filed as violations of Title VII, which, is the landmark federal civil rights law dealing with workplace discrimination.
A very powerful statute.
Super powerful. But the footnote highlights a massive omission. The judge writes that she, quote, does not allege that any of defendant's conduct was based on a category protected by that statute, such as race, sex, or national origin.
There it is.
And here's where it gets really interesting. I'm looking at the fact that this is an amended complaint.
Right, meaning it's a second draft.
Exactly. The plaintiff and her legal team had already filed an initial complaint. They reviewed the strategy, and they submitted a revised version to the court. And yet, they somehow still missed the most fundamental bedrock requirement of Title VII.
It seems impossible, doesn't it?
It really does. How does a legal team actually make that kind of omission? Is it just a typo, a sloppy oversight in drafting the document?
Well, if we connect this to the bigger picture, it is rarely just a typo.
Really?
Yeah. Often it reveals a profound disconnect between the reality of the workplace conflict and the strict requirements of the statute being invoked.
Okay, what do you mean by that?
So Title VII is not a general workplace civility code.
Right.
It was drafted to combat very specific systemic forms of discrimination.
Got it.
Therefore, to actually unlock the protections of Title VII, a plaintiff must explicitly tie the adverse actions they suffered, the demotion, the harassment, the firing, to a protected demographic category.
Okay, so if an employee comes to an attorney and says, my manager screams at me every day, sabotages my projects, and gave my promotion to someone way less qualified.
A terrible situation.
Awful. That employee clearly feels they are in a hostile work environment.
Right.
Like, that's a term we hear thrown around colloquially all the time.
All the time, yeah.
But you're saying that from a legal perspective, general hostility just isn't enough?
It is absolutely not enough. And honestly, this is where so many plaintiffs are just blindsided.
Because they think hostile means illegal.
Exactly. The phrase hostile work environment has a very specific legal definition under Title VII.
Okay.
And it requires the hostility to be discriminatory in nature.
I see.
If your boss is simply a toxic, abusive person who screams at everyone, or if they just have a personal vendetta against you because they don't like your personality.
Which happens a lot.
It happens every day. That might be horrific management, but it is not a Title VII violation.
Wow.
The law, essentially, allows your boss to be a jerk as long as they are an equal opportunity jerk.
That is a staggering reality check. Wow.
It's harsh, but it's the law.
So when we look at this failure in the amended complaint, right, where they didn't allege the conduct was based on race, sex, or national origin.
Yeah.
Could it be that the facts simply didn't support that claim? Like, maybe they knew the boss was awful, but just couldn't point to any evidence that it was because of her sex or national origin, so they tried to just, shoehorn a general bullying claim into a Title VII framework anyway.
That is a very common scenario in employment litigation, actually.
Trying to force a square peg into a round hole.
Exactly. Attorneys will sometimes try to stretch the fabric of a statute to cover bad behavior just because they don't have another viable legal avenue.
Right, they want to help their client.
Of course. But, as we see in this footnote, federal judges are tasked with holding the line on those statutory boundaries.
They're checking the VIP list.
They're checking the list. And if you read the text, the court isn't even saying Dr. Soysal lacked sufficient evidence of discrimination.
Right, because we aren't at the evidence stage.
Exactly. Yeah. They're saying she didn't even make the allegation. She didn't put it in the paperwork.
Oh, man.
And without that specific structural pillar, without alleging this happened because I am a woman or this happened because of my national origin, the entire Title VII claim just collapses under its own weight.
It really exposes the gap between what feels wrong and what is actually illegal.
It's a huge gap.
You can have pages and pages detailing a miserable daily existence. You can prove you were belittled and treated entirely unfairly. But if you don't explicitly anchor that narrative to a protected class, you are basically taking your grievance to the wrong venue.
That's a good way to put it.
It's like demanding a divorce from a traffic court judge.
Huh. Right.
The judge might completely agree that your marriage is terrible, but they simply don't have the jurisdiction to grant the request.
That captures the dynamic perfectly. The court is bound by the text of the statute.
Right.
If the plaintiff fails to construct the legal framework required by Title VII, the judge is legally obligated to dismiss the claim.
They don't have a choice.
No choice at all. They cannot read between the lines or infer a protected category if the plaintiff hasn't explicitly alleged it.
That level of rigidity is just...
Wow.
And it actually makes me want to examine the physical structure of our source document.
Let's do it.
Because there's a clue in the margins here that paints a much larger picture of what was going on in this courtroom.
Yeah, it wasn't a small case.
Not at all. We've spent a lot of time talking about this one fatal flaw, which seems like a basic, almost elementary error.
Right.
But the document header tells us this wasn't a simple, straightforward dispute at all. Right at the top, there is a visual note from the text that reads, quote, West Head Notes, open parenthesis, 16, close parenthesis.
Yes, the 16 head notes.
Yeah. So this raises an important question.
Wow.
What exactly are we looking at when we see a case with 16 head notes?
Well, this raises an important question about legal research. For context, when a federal judicial opinion is published, legal editors at companies like Thomson Reuters, which is the copyright holder noted on our source, they analyze the judge's written decision.
Okay, so they read the whole thing.
Right. They comb through the text and extract every distinct point of law, every separate legal principle the judge had to rule on.
Just to make it searchable.
Exactly. They index these and summarize them at the top of the document as headnotes. This allows other lawyers to easily search for precedent.
So if two parties go to court over like a really simple breach of contract, the judge might write a brief opinion and it might only generate, one or two headnotes because there's really only one legal issue being debated.
Precisely. But here we have 16 headnotes. 16. That tells us a tremendous amount about the scale and intensity of this litigation.
Right.
This was a sprawling, highly complex legal battle.
Yeah, it wasn't just a quick skirmish.
No, the plaintiff's legal team likely threw a multitude of different claims. State laws, federal laws, torts, just threw it all against the wall.
Hoping something sticks.
Exactly. And the defense attorneys countered with an equally complex array of procedural defenses and statutory arguments.
Wow.
The judge had to wade through all of that and make 16 separate, distinct legal determinations.
Which means this case consumed an enormous amount of resources.
Unbelievable amounts.
Right. Because when you have a case generating 16 points of law, you're talking about extensive legal research, massive briefings, and likely thousands upon thousands of dollars in billable hours from both sides.
Oh, easily.
It's a massive architecture of legal arguments.
It is. And that is what makes the juxtaposition here so striking.
Oh, I see what you mean.
You have this heavy machinery of legal system operating at full capacity, grinding through complex issues of jurisdiction, immunity, maybe intricate state laws.
Right.
Yet, right in the middle of this sophisticated legal war, 3 entire counts of the plaintiff's case counts, 3, 4, and 5, which were the Title VII claims.
Yeah.
They didn't fall because of a complex, nuanced interpretation of precedent.
They fell because of footnote 2.
They fell because the plaintiff forgot to check the most basic statutory box.
It's almost tragic when you look at it that way.
It really is.
To survive in a complex case like this, every single paragraph of an amended complaint has to be load-bearing.
That's exactly right.
It's like structural engineering. You can spend millions of dollars designing a building to withstand a Category 5 hurricane with the most advanced materials and complex architectural angles in the world.
Mm-hmm.
But if the contractor simply forgets to pour the concrete for the foundation, a gentle breeze is going to knock the whole thing over.
And in this scenario, the foundation of a Title VII claim is the protected category.
The race, sex, or national origin.
Yes. Without it, the claim isn't just weak. It is structurally non-existent in the eyes of the law. This highlights a critical reality for anyone navigating the legal system. Complexity does not excuse a failure of fundamentals.
You can't just distract the judge with fancy arguments.
No. You can hire the most expensive lawyers to craft a brilliant, multi-layered legal strategy, but if they fail to explicitly state that the harassment was due to race, sex, or national origin, all that complexity won't save the claim from being swatted away in a 2-sentence footnote.
Swatted away in a footnote. That is exactly what happened here.
Yep.
The Title VII claims were quietly dismissed in the margins, almost as an afterthought, while the rest of the 16-headnote battle just raged on.
It's wild.
It really reinforces why the drafting of a complaint requires such extreme precision.
Absolutely.
So what does this all mean? We've decoded this dense legal text. We've analyzed the strict mechanics of a Rule 12b6 motion. And we've looked at the massive disconnect between feeling wronged and actually stating a legal claim.
Right.
If you are listening to this right now, how do you apply this insight?
It's a great question.
Because if you are ever in a position where you are evaluating a workplace grievance, whether it's happening to you, someone on your team, or you're simply reading about a high-profile lawsuit in the news, you have to look past the emotional narrative.
You have to.
Good facts, even terrible, compelling facts of mistreatment, are not enough on their own.
Yep.
They must perfectly fit the exact shape of the statute you are invoking. If you claim a violation of a specific law, you must meticulously construct every element that law demands.
Exactly. And to summarize the final outcome of the text we analyzed today, because this is the key takeaway.
Yeah, let's hit that one more time.
Because the plaintiff, Dr. Soysal, failed to link the alleged conduct to a protected category. Specifically, she did not allege the conduct was based on race, sex, or national origin as required by Title VII. The court granted the defendant's motion to dismiss those Title VII claims.
Right.
The court assumed her allegations of workplace conduct were entirely true, but found them legally insufficient to trigger the protections of the statute.
It is a sobering reality check. And it leaves me with this final thought, a question for you, the listener, to mull over after we wrap up today's analysis.
Okay.
We've explored how this mechanism works and why it exists to save the court's time and money, right?
Mm-hmm.
But if a court is willing to look at a plaintiff, assume every bad thing they say happened to them is absolutely true, but still dismiss their case entirely because it doesn't align with a strictly defined protected category.
Yeah.
What does that say about the gap between our everyday understanding of workplace fairness and the rigid nature of the law?
It's a big question.
Are we comfortable with a system where you can be treated horrifically at work and the law simply shrugs because your boss was an equal opportunity tormentor?
Right. Just generally abusive to everyone.
Exactly. Is our current legal framework simply too narrow to capture the reality of modern workplace conflict?
Something we all need to consider.
It really is. It's something to think about the next time you hear someone say, "I'm going to sue." Because, as we saw in the footnotes of this decision today, the courtroom doors only open if you have the exact right key.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.